Alex here with a legal nuts and bolts video on attack, attack, attack. Don't take this video at face value. Some of you might assume that what it's going to basically tell people to do is just attack their ex or their opponent so frivolously and frequently that they just give up their case. And that's not what this video is about at all. Also, I could have made this a high conflict child custody video because that's mainly where I apply this principle, but it really applies to any kind of court case, so I decided it would be more appropriate as a legal nuts and bolts video. So going straight into it, I'm going to use examples of what I'm talking about because that's actually what relates to people the best, and they're pretty much all going to be examples from my child custody case, but as I mentioned earlier, you can really apply this to any type of court case, and you really should. So what this video is about, if it's not about burying your opponent in paperwork and making them spend all their money, then what it is about? It's about what not to do. And what I'm going to go into right now is a mistake that I made with the first 2, maybe even 3 years of my child custody case. I'm going to use my child custody examples because they're actually the most vivid in my mind. And what would happen is this: my ex would commit some kind of conduct, and then I would have to file a motion to deal with that conduct, whether it was not telling me about an appointment or violating the court's order. And once I filed something with the court, a motion for order to show cause or a motion for some kind of behavioral order, other things would occur. And I'm not quite sure if my ex was ramping things up because I had filed a motion and she was basically thinking, well, now that I've filed something, I'm not going to file something else, especially because the judge constantly made comments about that, about me filing too many papers. Or if it was just really random and just something that she was just doing without thinking. But what I would do is, because I had a motion pending, I would decide not to file anything else until that motion was resolved. And really what it came from 2 feelings. First was fear. I was afraid that without seeing what the outcome was going to be on the first motion, then how should I know whether the court's going to care what I have to do or what I have to say or ask or request with the second motion? In other words, maybe a small part of me wanted to see if the motion would be denied, and based on that order denying, I would not file the second motion. And really I've talked about this fallacy before. Each thing that you request from the court is completely separate and is considered independently of each other thing that you request from the court. And a lot of times, when it comes to our normal world interactions, our non-court interactions, with whether it's a coworker or a family member, a lot of times we do base our decisions on the kind of feedback that we get, regardless of whether or not the issue that you bring to your family member, friend, or coworker is different or not. It's just it's an emotional world we live in, and decisions get made based on those kinds of sentiments and reactions that you get from those other people. But the court isn't like that at all. In court, you could ask for a modification of child support and get chewed out by the court for whatever reason. Maybe you didn't show that there was a change in circumstances enough or something. And then you can file a motion to modify custody or for order to show cause, and having just been chewed out 2 weeks ago, you just win outright. And it's very mind-boggling for the non-attorney, because it's just like, does the judge hate me? Does the judge like me? And it's not how you should look at the court system at all. As I've mentioned before in a previous video, the judge does not remember you. They're only looking at that one issue. And so going back to what I was going into is that fear of filing something and wanting to wait until it's resolved before filing something else is just not conducive to how the court system works, and it's pointless. And in my case, I considered that there was a possibility. I wasn't for sure on this, but I thought possibly that my ex could sense that fear, and once I had filed something, she would do a bunch of other things, knowing that I wouldn't file anything else. And then, of course, the second, I said there was 2 reasons, and the second reason kind of ties into the first reason. The judge had said before, numerous times in court, that he didn't like numerous motions being filed. He didn't want us to come back to court. I'm going to cover this in a separate video, this fallacy that certain judges have as to this assumption that if things are being filed, the parties aren't getting along, and if things are not being filed, then everything's going well in the home. It's not true at all. And anyway, I'm going to cover that in a second video. But what I was saying was that the court had even said, I don't like a whole bunch of things being filed, and so internally I would think, you know, I don't want to file a second and third thing, knowing that he said last time that he didn't want to see a bunch of filings in this case anymore. And of course, it's illegal. It would get, I mean, any kind of order from a judge saying that you can only file a certain number of things in a certain amount of time would be considered unconstitutional, because we're supposed to have our access to the courts. Anyway, the point I'm trying to make here is, do not hold back if you have a valid issue that's in court and you have another valid issue that comes up while that issue is pending. This video is not about filing so many pieces of paper in court that your opponent gets frustrated and spends their money. It's about telling you not to hold back valid issues just because a valid issue is pending. So, for example, there was one time that I had filed a motion for a modification of custody when my ex wasn't taking our son to school. There were a bunch of absences that had accrued. And then there was also an issue of child support that needed to be addressed. And I was just concerned that if I filed that at the same time, that I would look bad. And as I've mentioned, you know, just a few moments ago, if it's a valid issue, if child support can be modified based on actual, you know, you've done your research, you looked at the law, you're not just filing a second motion to just pile it onto the first just because you're vindictive or you want to harass your ex, but you have a valid issue before the court and you have another valid issue, which in this case, I'm giving the example of child support, you should just file it when the issue becomes relevant, because stretching the time out, it doesn't do your child any favor if it's a child custody issue, because then your child is going to suffer the extra number of months that it's taken the court to resolve the previous issue. And if it's a child support issue, it actually hurts you because I'm not sure if many people know this. I mentioned this in my child support video, but you can't retroactively modify your child support to any date before the filing of the motion. So you're either hurting your child or you're hurting yourself. You know, and in the sense of child support, you shouldn't be paying child support if your income has, you know, a certain amount of child support. You shouldn't be paying that same amount if you've lost your job or some other issue like that has come up and the child support needs to be modified. Again, don't hold back a valid issue if you have a current valid issue pending. You just need to file it. Another example I have is on an appeal once I filed. This appeal was related to me asking to you know, enforce child support arrearages that my ex owed. And the court denied my motion and imposed sanctions. So I filed an appeal, and I did eventually win that appeal, but that's not the point of this video. I filed my appeal, and while my appeal was pending, my ex committed or was not responding to emails concerning healthcare that our child needed. And there were 2 or 3 different contempt of court issues that had come up. Now, at this point, I'd learned my lesson, and I'd stopped just arbitrarily just holding off on issues when another issue was pending. I stopped caring how I looked. I stopped caring, you know, what the judge would think of me. At this point, I had already decided that I was going to get justice from the appellate court, so if my judge didn't like it, too bad. And I had gotten it through my head, by now we're in year 5 or 6, that if you're in the middle of an attack and you have another issue that comes up that's valid, attack on that one too. And if you have a third one that comes up that's valid, attack on the third one too. The point is, they are valid issues you need to bring to the court's attention. There's no reason to wait. And in this case, that appeal could have taken 6 months to a year. It ended up taking, I think, 4 or 5 months. But I didn't want to wait and see. I mean, I had filed my appeal, and you know, this issue with contempt of court, she just committed more violations. I didn't want to wait on that. My appeal is pending. I'm going to file that motion too. And then the whole issue with not responding to emails so I can get our child into, it was an optometrist appointment, and possibly a dental one, I can't remember now. That was an issue. My ex wasn't responding to me. I needed to modify legal custody. It was a valid legal request. I wasn't just filing this third motion to harass her or to overwhelm her. It was a third motion that needed to be addressed, and I could not wait for the appeal nor the previous motion to resolve, so I filed a third one. Hopefully that I've explained some of the fears so that people understand where that fear is coming from and they override it. Lawyers don't have an issue with this because it's impersonal. They've gone to school. They're trained in it. But us, you know, regular people who haven't gone to law school, who aren't doing it for a profession, I mean, it's a mixture of fear, not wanting to look bad, you know, not knowing, not having gotten any feedback on the previous things that you needed to ask about. You just have to, you know, you have to attack. If you're fighting for your kids, if you're fighting for what's best for your kids, if you're bringing issues to the court that are valid, they have merit, you're not just harassing your opponent, you have to fight. You have to do it now. Don't wait. I've seen people do that before, and it doesn't make you look any better. It doesn't increase the likelihood of you winning. And it doesn't even decrease the likelihood of you being sanctioned. Because, honestly, by the time you file your second or third motion, your ex's lawyer is not going to care. Your opponent's lawyer, in case it's not a child custody case, they're not going to care that you're not filing things at the same time. They're still going to say that you're harassing them. They're still going to ask for attorney's fees. You know, I mentioned this in another video as well, that they're never going to say good things about you. So if you're thinking that your opponent is going to be nicer just because you spaced your requests out, you're living in a fantasy world. It's not going to happen. I'd be surprised if by the time you went back to court the second time, not even the third, fourth, fifth, just the second time, I wouldn't be surprised if your opponent's attorney was saying that you needed to be sanctioned and pay for attorney's fees because you're harassing them. So, I mean, you're going to get the same exact treatment if you file these issues, if you request relief on these issues at the same time. Then if you space them out. And if you think the judge is going to like you any better, I mean, I have to say, you know, the court, honestly, if you could cluster these things up and the court could get them resolved all in one hearing, I think that the court would like that better. You know, despite the fact that a judge may, you know, say things about not filing any more papers and it's annoying them and you need to just get along and work it out and take the high rate, all that arbitrary nonsense that doesn't work in a high conflict case. Honestly, I think that there were a few times that my judge mentioned, are there any other issues? Because I just want to get them just resolved right now. In a way, it's even better if you just clump them all together, no matter how bad it looks, and just get them resolved in one clump, rather than waiting for a hearing, seeing what happens, filing something else, waiting for the hearing after that. It just strings the case along for months on end. Towards the beginning of my child custody case, that's kind of what that's kind of how things went. The issues were just stringed along. And towards year 4, 5, 6, and on, I had a lot of peace and quiet, and then really dense moments of a lot of activity, a lot of legal activity. And I think the court liked it better. There was going to be one more thing I wanted to mention. This is slightly on topic, slightly off topic. If you file a motion on an issue, for example, a motion to modify child custody, and let's just say it's based on not taking the kids to school or something like that, and you have another factual incident that occurs, let's say domestic violence, even though it's the same thing that you're trying to do with that factual incidence, you're trying to modify physical custody for not taking the kids to school on one hand, and now you have a new issue that you didn't know about that came up. You found out about domestic violence and you want to modify physical custody on that. Some people make the mistake of just not filing a new motion and just deciding to bring it up in court. And a lot of times you'll get accused of ambushing your opponent. You'll get a lot of resistance from an opponent attorney. Unless the incident happens like 2 days before the hearing, even though you've already filed a motion to modify physical custody, you should file a second one addressing the new factual incidents that have come up to give your opponent a chance to oppose your first motion and your second one separately. Like I said, don't just not bring it up in writing. You'll probably be fine. Judges are understanding in child custody cases. If it's not a child custody case, then you better file a motion, because in non-domestic relations matters, the courts can be pretty ruthless about this stuff. But I mean, just to be safe, you should bring that up. I know some people have an issue with that because they think, well, I've already tried to modify custody. I don't want to look bad for filing another motion when I haven't even gotten a ruling on the first. The fact of the matter is, your first one didn't bring up the domestic violence. You didn't know at the time. You need to bring it up in writing so that your opponent can do their research and oppose it in whatever way they may have. And another tidbit that I wanted to say is, sometimes people try to amend their previous motion or file like a corrected one. I feel like it just complicates things even further, messes with the deadlines on when things are due. A second one is probably just a whole separate motion is probably better. You can even refer to the first one in there in case you're worried that the court's not going to know that there's a second motion to modify custody pending. And anyway, I hope that little extra detail at the end answers a few questions. I kind of decided to piggyback that onto this video, but I mean, in the spirit of filing 2 or 3 serial motions, it does follow the title of the video, which is to attack, attack, and attack. So again, as I mentioned in a lot of my videos, if you have any questions, just mention it in the comments below. Any examples where you had issues like this occur in your case, that you had an issue that you wanted to bring to the court's attention, but because another issue was pending, you were afraid, you wanted to wait until that first issue was resolved. Especially bring that up in the comments if that came back to bite you, because people need to see that. I mean, a lot of dealing with the court system is pushing through the emotional obstacles that get thrown up. I mean, if you're not an attorney and you don't have the training, it's a lot of the times you're either being psyched out by your opponent or you're psyching yourself out. And that's what this channel is about. It's about getting past those disadvantages and putting you as on equal footing as I possibly can to the attorney that you're going up against. Or if you're lucky enough not to be going up against an attorney and it's just both of you representing yourselves, to get a little bit of an edge in your case in taking care of your side of the story. So with that, I'll go ahead and end this video.